Thank you, Mr. Chairman, and members of the board. As you know, I'm Will Dunaway of Clark Partington Law Firm, and I support your General Counsel Meredith Clark Partington Law Firm, and I support your General Counsel Meredith Bush, who's asked me to open this discussion along with your Executive Director. Board members, if you'll recall at your last board meeting, Ms. Bush advised you that on September the 5th, the county commissioners denied your request for an exemption of the incremental tax. And on September the 6th, Ms. Bush received a letter from the county's attorney informing her and you of that action and requesting payment of the tax increments which they had calculated in the amount of $1,134,025, which covers three FYs, FY 21, FY 22, and FY 23. The request was that those funds be remitted to the county within 45 days. That date would be October the 21st of 2024. We were asked to review this, and as I know you understand this, but when a lawyer sends a lawyer a letter, the two organizations are communicating with the lawyers. There may be some issues with regards to the law in that area. And so would that all of the issues that we deal with are very, very clear from a legal perspective, this is not one of those. However, in our research, we have done what we believe to be both an exhaustive legal research of the applicable statutes and the procedures that we have. Your executive director, through your state organization, has also requested a legal opinion, and you know, helpfully their analysis matched with that of your general counsel, Ms. Bush, and myself, and it leads us to the recommendation that you received in the background materials, or the background materials that you received last night, laying out this issue. Before you is the request from the county to provide the tax increment funding for the 3 years. So your three options that are before you are as laid out in the background material. Authorize your executive director to remit those full funds, pay the current year. Option number 2 would be to pay just the current year, and then option 3 would be to not pay any of the funds. No option has a clear legal answer on either side. I want to be clear about that. If you were to pay, if you were to choose option 1, which would probably be the you know, easier from the county's perspective, that's what they requested. We do know that there's case law that indicates that such a payment could be unconstitutional. Option 2 is the compromise option. That is to pay the current year. That is the year that the county requested this payment. In your earlier years in tax increments, obviously, as you are aware, budgets are built both at the county and the school district and in this organization annually based on taxes that are annually received. And there is a process, of course, that we work through with regards to exemptions that contemplate an annual process. Nevertheless, option 2, again, the compromise option has legal risk on either side. And obviously option 3, which would be the opposite of option 1 in the favor of the trust, that is to not pay it, which, you know, again, you have a legal obligation and a fiduciary obligation to both follow the statute and to protect the funding for the sources that it comes to. I do want to say that in this regard, and I am here to take any of your questions, I hope there will be robust discussion, but I do want to move into the second role of why you hired Clark Partington, and that is we're both lawyers and counselors at law. I'd like to move a little bit into the counselor role. Your mission is to service children and to care for children in this county. Children cannot be adequately served if you are at war with the governing body of the county. It is nothing that you do not want to be in that position. We want to, you as an organization have and certainly are continuing to strive to have good relations with the county. And in this case, I think there are opportunities for improvements in that area. We know that in this area, funding for services in the CRAs was an issue that the county commissioners articulated. The information that we had in the communications back gave us an insight into their thoughts. And their thoughts are, we're not doing enough. The process of the statute is very clear that it does provide for a mechanism to enter into an interlocal agreement with the county to provide these fundings. And that is what compromise option number 2 would allow you to do. If the county were to grant an exemption, and then in this case, I do understand and don't misunderstand, they did not. I think that you have an option to, or you have the opportunity to better educate and better provide information about how you are helping and will help in the future in those areas. So option 2 does provide that opportunity. It provides the funding for this year, which was requested, and it then allows for further discussions with the county and potentially agreeing to going into the interlocal agreement. I know, and I want to be open to your questions. I don't want to overstep from the boundary of a legal. I can go through, if you'd like, some of the issues as to, why there's no clear legal answer in this regard. You would think that, given the fact that you're not the only, or actually you're the newest of the Children's Trust in the state, that others, for the most part, this situation has not been a controversy in other areas, and it's handled through the interlocal agreement with the governing body. So maybe it's a learning process for this board and for our county. Again, I just think that as your counselor in this regard, that you want to be cooperative and working together for the provision of services for children, and that is a win for everyone. And it's not a win if either side bows up and goes to war legally.